on September 24, 2011, as part of its examination of the rule of law in times of terrorism, the section of litigation interviewed Michael Mukasey, the former Attorney General of the United States.
Good morning. Judge, thank you so much for being with us today.
Thanks for having me.
I just would tell the audience that when I was talking to Judge Mukasey outside, he said that he has a longstanding affection for this section, in part because of his affiliation with our own former chair, Lorna Schofield. So I want to extend our appreciation to Lorna as being part of the reason that we're graced with Judge Mukasey's presence here today. As you know, we had a panel yesterday on the proper place to try terrorism suspects. And I don't want to go over all of the issues that were raised there, but I know this audience would be very interested in some of your comments about some of the topics that were raised yesterday. So I wanted to start with the ultimate question in a way, and maybe then work backward and talk about some of your reasons. Where do you think terrorism suspects should be tried in this day and age? And if it's not in an existing format, what should it look like?
Okay. That depends, I guess, in part on where they're caught and under what circumstances. We now have a binary choice. It's either military commissions or Article III courts. I'm not convinced that that's necessarily optimal. We may long-term need a national security court, which would combine some features of both.
Well, talk to us a little bit about what kinds of people you think might best be tried in national security courts, and what kinds of people might best be tried in one of the two binary choices we have right now.
Okay, I think the kinds of people who might best be tried before national security courts are the people who will now be tried before military commissions. I don't think that the military, we've had military commissions throughout our history, from the Revolution through and including World War II, but I don't think the military is ideally suited to run a parallel justice system. That's not what they're in the business of doing. They're in the business of winning wars. And I mean, you do that principally by killing people and blowing stuff up, which is, I mean, it's very important that they do that and that they do it well.
Correct.
But running a parallel justice system isn't really part of that. And they can do it on an ad hoc basis. They've done it on an ad hoc basis, but doing it long term, I think, diminishes their edge. They don't have a, just to take the most mundane thing, there's no real promotion track for somebody who is involved long term in this kind of thing.
Well, I want to come back to that, but before I come directly back to that, let me ask a more preliminary question. On what do you think the considerations, or what considerations do you think should underlie the decision as to where to try terrorism suspects? And for example, isn't the ultimate question whether or not the trial, wherever it's held, has enough substance and perceived process to be deemed legitimate? And isn't that question more important than the particular forum in which the trial is held?
I don't know about more important. In order properly to call it a trial, yes, it has to have substance in the sense that the outcome cannot be predetermined, and the process must be an adversarial process. It must be presided over by a neutral person. And
so as our moderator yesterday, Steve Salzberg, said, losing should be an option.
It has to be an option, otherwise it's not a trial.
Okay.
That said, the principal consideration is the security of this country. And on that is going to hinge on a couple of things, including the identity of the defendant and the nature of what it is he or she is charged with. There have been very few she's, but I have to
contemplate the possibility.
Have to contemplate the possibility. At least one mullah who is famous as a moderate has issued a fatwa authorizing women to conduct suicide bombing. So it's very much an equal opportunity enterprise.
Well, I don't want to force you to defend something that isn't necessarily defined by you as an ideal, but I know you're certainly well-versed in the current military commission. So let's talk about them for a couple moments, if we might. And I guess one of the questions that I have about military commissions is the extent to which they interfere with the perception of fairness. And I wonder, for example, whether or not the way in which military commissions are comprised and conducted undermines their effectiveness as being received outside of our borders as a fair venue for trials?
I can't see why. The fact is that the evidence has to be presented in a forum that is, except for classified information, open to the entire world. I mean, I visited Guantanamo when I was AG in 2008. They have a world-class facility that I've never seen in any federal courthouse.
When you say world-class, do you mean physical?
Yes, among other things.
And beyond the physical, what
right.
else?
The people there are enormously dedicated. They have a cadre of military judges and prosecutors and defense lawyers who are intensely committed to what it is they do. But the physical facility itself is set up for huge press gallery, completely accessible, can process classified information remotely so that you don't have to worry about transporting stuff and failures of security and so forth, and built at an enormous cost.
But isn't the nature of the proceeding, the nature of the fact finders or decision makers, as it were, the fact that they are enormously dedicated, which I think everyone in this room would concede, doesn't their status as military people, though, interfere with the perception that the process is fair?
I mean, because is somebody going to look at it and see folks wearing uniforms and stop any other consideration of what it is that goes on there?
Yeah, I wonder about that. And this series of questions I'm asking really has to do with international perception, and we could then talk about the extent to which that ought to drive the decision. But I wonder, for example, whether the fact that the decision makers are military people who report to the president, who report to our current president, who was reported to have said losing is not an option. I wonder whether we could ever successfully mount a trial in that setting that would have the kind of legitimacy that some people would feel is important.
I think that all that reflects is that politicians generally, and maybe the Attorney General said the same thing, regrettably, ought not to
I might have ascribed it to the president instead of the Attorney General.
Ought to be very careful about what they say on subjects like that. I don't think that trickles down to the judges. It certainly doesn't if you look at the record, which includes numerous, to the extent there have been trials, both verdicts and sentences that have been way on the lenient side. Osama bin Laden's driver, having been convicted before a military commission, was sentenced to something like 6 years, which wound up essentially being time served. Now, for a civilian judge, just take a conventional organized crime case. The driver is one of the most trusted, if not the most trusted member of the family, because he is A, responsible for the boss's physical safety, and B, sees and hears everything. So it's got to be somebody of substantial respect and rank. This guy was apprehended with 2 rockets in his possession that were intended to be used on U.S. troops. I don't know whether they gave them those back after they finished the proceeding or not.
Let's hope not.
But the fact is that under conventional international law, people who violate all of the rules, I mean, who follow none of the rules of military conflict, who do not wear uniforms, don't carry their arms openly, and target civilians, we are authorized to keep them in custody essentially indefinitely. This guy got a 6-year sentence. There was a good argument for simply moving him, to the next cell and saying, okay, you've now served your punitive sentence. You're now about to be held because you're an unlawful enemy combatant and subject to detention essentially at our convenience. But it was felt that the public wouldn't swallow that, and so he was sent back to Yemen.
Right. I can think of several directions in which to go.
That's the outcome of a military commission trial that I don't consider to be particularly satisfactory, but not for reasons that you suggest.
Right. No, I understand that. Let me ask you a question about detention. You alluded to that in your last response. And I know that you've talked about the absence of an appropriate detention policy in this country as contributing to the current state of things. Could you talk a little bit about what you think ought to be done in that area?
Well, I'm certainly not the only one who's talked about it. The
I mean, you
generals,
talked about it to me.
the generals who, the generals who have to do it have pointed out that we have no coherent detention policy. The current administration, as I understand it, relies on the authorization for the use of military force that was passed right after 9/11. That statute is notable for a lot of things, including the fact that it does not include the word detention, let alone set the standards for determining who should be detained.
And yet it's used that way.
Well, yeah. I mean, the administration's position is that implicit in the authorization for the use of military force and for engaging in combat is the authorization to detain people. Okay, that's fine if you're in a setting like World War II, where everybody kind of accepts the overall goal. And we detained hundreds of thousands of people during World War II, many of them here. Not one of them filed a habeas petition, and they were not allowed to do it.
Is there anything unusual that you think would be the components of an appropriate statute, anything that the average person wouldn't assume to be part of it if they agreed it was necessary?
I don't know about whether the average person wouldn't assume it. I mean, you'd have to determine, for just as a basic matter, who gets tried and who doesn't. People who commit war crimes can be tried. People who are captured under circumstances indicating that they are unlawful enemy combatants can simply be detained. It's not a punitive detention. Now, I realize that if there are bars on the window and
it's going to look a lot like punitive detention.
It's very hard to kind of tell yourself, I'm not being punished, I'm just being detained.
And what's the outer limits of the detention?
Cessation of hostilities, or having the person no longer be a danger. I mean, in my view,
yes.
Having the person no longer be a danger.
How will we ever know if they're detained? How will we ever know, let me ask that question more appropriately, if they are detained, how will we know when they cease to be a danger?
Well, presumably we have information that accounted for their detention initially.
Sure. But
and then somebody would consider it periodically and see to what extent it's degraded over time. I will tell you that under the current system, there is no limit. We have 50 to 100 people who get to file, thanks to Boumediene, who are detained at Guantanamo, get to file a habeas petition or something like it.
Right.
Query what it really is, and there depends really on which judge you get down the district court in D.C. The D.C. Circuit is still putting that together, believe it or not, 10 years after the event. They get one shot, they get one bite at the apple. And once the determination is made that they were detained lawfully, that's it.
And in your world,
in my view, it shouldn't be that way.
There would be periodic review.
Yes.
In a contested proceeding.
Yes.
Okay. Let me go back to something
but
you
that,
said.
Even that periodic review. The question is, I mean, who would qualify for detention?
Right.
Let's assume that a person is everything that the government says he is. Is that the sort of person that the government should be allowed to detain? Who has the burden of proof? All of these things are, and what is the burden of proof? Still up for grabs.
Do you want to tell us what you think, or if not, let me ask how we should go about answering those questions in your judgment?
I think we should go about answering those questions by having Congress pull up its collective socks and consider the matter in an intelligent way and pass a statute that contains standards for doing it. I think they should be standards that are highly respectful of and have a very light hand on the military, because wars are principally about what the military does. They're not simply trampolines for lawyers. When I hear that lawyers are involved in target selection for drones, you think back to World War II. I mean, can you imagine a lawyer sitting at the elbow of Curtis LeMay,
right.
figuring out...
Here's what I think.
Yeah, I mean, that would have been a very short conversation.
I'm watching the time go by, so I'm going to keep moving, and I apologize for jumping from one topic to another. You suggested that the military are not trained for the role to, in the long run, to run military commissions. There's no promotion track for it. So let me ask, I'm leading up to a question about national security courts, but along the way, let me ask about Article III courts. You presided over a terrorism trial. And so I'm interested in why, having had that experience, it doesn't lead you to think that that is an imminently workable model.
It is, for one thing, a huge security problem. Just take a simple thing like picking a jury. The jurors in my case were selected anonymously, as jurors in organized crime cases are frequently. We took enormous pains to make sure that they were kept anonymous. They were picked up every morning at sites remote from the courthouse, brought to the courthouse by the marshals, kept basically with the marshals throughout, dropped off at different drop-off points afterwards to make sure nobody followed them. They had numbers so that even I didn't know their names. The day of the verdict, 2 of them found journalists at their doorsteps, and that's very easy to explain. These people don't come from Mars. They all have friends and family who know that they were called down for jury service the day of the big trial, right? And guess what? They don't show up for work or whatever for some period of months that happens to coincide with the length of the trial. And everybody's got one good friend, right? So, and one of the good friends is bound to be a journalist. And just consider you've got 18 people, 12 jurors, 6 alternates. Somebody's going to find out.
But you alluded to
that's just the jury.
That's just the jurors. But you alluded to the fact that we do this in organized crime trials. We do this in high-profile trials all the time. And I guess some people, myself included, would wonder whether the obstacle is enough of a reason not to pursue.
It is. I mean, these folks, organized crime people, say what you will about them, have one thing going for them, which is generally they're into prevention, not into revenge. These folks are into revenge, and you can't assume that once the trial is over, the danger is over. It's just beginning. We have, in addition, the enormous cost associated with protecting the courthouse and its environs. And then
why would it have to happen in a courthouse? Couldn't we do an Article III trial in a more secure location?
Well, there are in fact a series of statutes defining the places for holding court. I saw some amusing articles, but some of them by people who should know better, about convening a district court at Guantanamo. And in addition to thinking about, okay, where do you get the jurors and how do you right?
Undoubtedly logistical challenge.
Okay, as far as I know, there is no statute authorizing a place of holding court at Guantanamo. So, I mean, past that, it's just a myriad of problems. But the evidence gathering that goes on under the circumstances in which people are captured is very different in a criminal case from what it is in a terrorism case where somebody's captured on the battlefield. I mean, we can't expect Marines to do CSI Kandahar when they take somebody into custody on the battlefield. So you can't necessarily have items of evidence with a precise chain of custody, and you don't necessarily want the first words out of the mouth of a soldier to be advice on Miranda rights, because, I mean, unless you're going to have a defense lawyer assigned to every combat team, telling somebody you take into custody that is entitled to a lawyer doesn't have a whole lot of meaning. I mean, it's farcical, and the fact is you simply can't try people like that in an Article III court and obey Article III rules. Part of the problem with bringing them into Article III courts is there's an almost hydraulic pressure to fit the case into the forum, and so you wind up distorting the rules that apply not only in the case in front of the court, but because it's an Article III court, apply in other cases as well, and there's a danger of that.
I have just a couple more questions, and then I'll open it up to the audience. Who would be the decision maker in the National Security Court that you think might be a better alternative? Who would be the decision maker?
Same decision maker as in military commission.
Well, that's what I thought. So then the question I have is this.
Military military jury.
Don't members of the public have some right to have a say in these cases that we get by our role as jurors in traditional Article III courts? And isn't that a loss that, or how do you feel about that loss?
No, and not very bad. jurors are fact finders, and they swear to simply decide the case based on the evidence. They're not there to, quote, have a say, unquote. They're there, in fact, not to have a say. In fact, we have a screening process that makes sure that they understand that that's not what it's about.
Let me be at least a little clear about what I meant by the question so that I don't mislead you. I don't mean that jurors ought to come to trials, any trials, with an agenda. I agree with that. But at some level, the repeated sense of jurors' reaction to cases gives us some societal norms about what we think through jurors. That's really more of what I meant, and that was the loss I was asking about.
Okay, that's a loss, but when you consider that it's to be done in a transparent forum with a record that can be looked at to the extent that it's not classified by the entire outside world, then I think that loss, candidly, is worth it. And we've had Article III trials, and I don't want to say that we got 9/11 as a result of having Article III trials, but it sure as hell didn't stop it.
You told me that I could ask this question. The notion of interrogation techniques and the extent to which the interrogation techniques of terrorists can be thought more broadly defined than those that we're used to in civilian and domestic cases. Could you talk a little bit about what your sense of the appropriate limits are, if any?
The appropriate limits are set by the law. And the purpose of interrogating captured terrorists is different from the purpose of interrogating defendants. It's done for the purpose of gathering intelligence. That's the only reason that the CIA interrogation program existed. And the fact that it doesn't exist now, I think, is highly regrettable. It was done to collect intelligence, and it was enormously successful in collecting intelligence. There are statutes that were up until, I guess, 2005, there was one statute that was principally relevant, and that was the Tortured Statute. Despite the fact that it's become a figure of speech, it actually is a precisely defined term. It means subjecting somebody under color of law to severe, not just pain, but severe physical or mental pain or suffering. Severe mental pain or suffering is defined in durational terms. Severe physical pain or suffering isn't. And just to jump ahead to the 800-pound gorilla in the room, waterboarding, that was done to 3 people. And I can't say that that was successful, because the way it works is not that somebody is questioned either while being waterboarded or immediately afterwards, but rather somebody is found to be somebody who is likely to have very valuable information and is not being cooperative. And then a range of techniques are used until they get to be cooperative, of which that is one but not the only one. And then after they indicate by word and deed that they're cooperative, somebody else comes in and resumes the questioning. That said, there were 3 people waterboarded. And when you consider the number of journalists who've written articles about having personally undergone waterboarding, and I think I've never read an article that said it wasn't torture, although none of them refer to the statute. I think it's clear that more journalists have been waterboarded than terrorists, which, and I mean, it's not just a kind of a funny statistic, because I think what it lifts the lid off is the fact that if you want a kind of curbstone definition of torture, it's something for which nobody would volunteer.
Right.
I mean, I don't think nobody would volunteer to have their fingernails pulled out or to have electrodes attached to their genitals or anything like that. So the fact that people are volunteering for waterboarding, I think, kind of tells you a little bit about whether it's torture or not.
My last question really has nothing to do with where we should try terrorists. It has to do with this. You have had a very long career, a successful career, one that has lots of different elements. You've served as a judge, you've served as an attorney general, and now you're in private practice. Just in this era, as we think about the future of our legal profession and we think about bringing new people into this profession, just give us a couple thoughts on those 3 different jobs and which one you like best.
Which one I like best? I joked with you outside that it depends on what time of the month you ask me, because at the end of the month, obviously, I like the one I've got now. It's payday. But no, in all seriousness, they're all 3 of them about about being lawyers. And if that's, it's the ultimate collision between theory and life. And if you hold to the belief that you can try to organize human affairs in a rational way, try as hard as you can, and still keep people safe and happy, then you're a lawyer. And you try to do that in whatever setting you do it to the best of your ability.
Thank you.
And that's what
One
all
or two
those
questions?
three things had in common.
Your Honor, turning to Van Louden, it seems pretty clear that the government made a decision in advance of capturing him that they were going to execute him without any due process, because they obviously had him surrounded in his compound in that room, and they could have shackled him, done whatever, taken it without shooting him, because he was not armed, from what the report is. As Attorney General, former Attorney General, how do you feel about that decision? It seems contrary to our normal way of dealing with captured people.
Well, I actually feel very good about that decision, because, I mean, and let me get to the reasons later on, because I think if there was anybody who needed killing, he was it. And not only that, but he needed killing at the hands of U.S. soldiers. That said, I don't think those soldiers were under orders simply to kill him. I think what they were told, and what soldiers are always told in that setting, is that if he makes an unambiguous attempt to surrender, then they'd have had to take him into custody. I seriously doubt that he made an unambiguous attempt to surrender. Now, if you were there in the room and you come upon bin Laden, are you willing to bet your life and your family's future on the fact that he's not wired, isn't ready to set off a bomb, doesn't have a gun handy, and a whole lot of other things that you're probably not willing to bet on? I don't second guess military folks who act in that setting. I think the really regrettable part is that we talked a lot about how rich the trove of intelligence was that we captured at the time, which has to have alerted a lot of people around the world who dealt with him to adjust their daily schedules at a minimum. If we kept quiet about that, my guess is we could have gotten a whole lot of other people. And as far as shooting him or not, I mean, we hit people with drones all the time. I'm in favor of that as well, provided that the target selection is careful. But yes, war is hell, and